What a walk down memory lane of all the very interesting webinars we have had in the past. And I know we're going to hear some incredible information today. Good afternoon, good evening, and good morning to all of you joining us today from wherever in the world you are. My name is Jacqueline Scott. I'm the president-elect of the Union Internationale des Avocats, UIA, or International Association of Lawyers. Today, we are delighted to welcome you to the 2023 Rule of Law Webathon Week, organized jointly by UIA IROL, and that is the Institute for the Rule of Law of the International Association of Lawyers, the American Bar Association International Law Section, the Human Rights Committee of AIJA, International Association of Young Lawyers, and the Inter-American Bar Association. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense when the rule of law is under attack. For lawyers, the rule of law is not merely our stock in trade, it is our core value. And it is this universal commitment of all the world's lawyers to the rule of law that was the inspiration to join forces and launch this year's third annual one-of-a-kind Webathon, and we are very proud to be a part of it. This year's theme for the Webathon is Upholding the Rule of Law in Challenging Times, and the Webathon is composed of 9 separate panels throughout the week that are dedicated to exploring, analyzing, and presenting perspectives on various challenges to the rule of law, including climate, economic, migration, security, and armed conflict crises, to name just a few. This afternoon's panel, Holding the Rule of Law in Times of Armed Conflict, Acting in the Present, Preparing for the Future, is the fourth of the 9 Webathon panels and will focus on the impact of armed conflict on the rule of law. Armed conflicts, whether of international nature or not, have driven millions of people across the world into crisis. Such conflicts have resulted in serious violations of human rights law and grave breaches of international humanitarian law, including war crimes, crimes against humanity, and genocide. Most recently, human rights organizations, as well as international and regional institutions and courts, have responded with exceptional speed to the invasion of Ukraine by the Russian Federation and to the atrocity crimes committed in the context of the armed conflict that has followed. The prosecutor of the International Criminal Court has opened an investigation into the situation in Ukraine and is working closely with regional organizations and a number of states to collect and preserve evidence in order to start criminal proceedings, both domestically and internationally. On the diplomatic level, intense discussions are taking place for the creation of a special tribunal on the crime of aggression. The war in Ukraine has raised interesting and increasing interest in international law, its strengths and how it operates, but it also points out its limitations in terms of restraining and punishing aggression, putting an actual stop to the commission of war crimes, and ensuring full accountability of the perpetrators, including at the state level. Today's panel of experts will address the main legal concepts relevant to the protection of the rule of law in the context of conflict and in post-conflict situations. Our expert panelists will discuss how the rule of law is an essential pillar necessary to prevent, repress, and redress serious violations of human rights law and grave breaches of international law, including war crimes, crimes against humanity, genocide, and the crime of aggression, all with the goal of ensuring peace and security. They will also share with us the particular challenges these situations raise in terms of prosecution, particularly the coexistence and efficiency of establishing both state responsibility and individual criminal responsibility. So, without further ado, allow me to introduce our moderator, Julie Goffin, Director of UIA's Institute for the Rule of Law, as well as an international criminal lawyer acting before international and regional courts and a professor of international criminal litigation. Julie, the floor is yours.
Thank you. Thank you very much, Jackie. I'm really delighted to be the coordinator on this panel with 4 brilliant speakers who will address some of the many issues that we will discuss during this panel. Since this panel is scheduled for 2 hours, we have plenty of time for questions. So please do post your questions on the window which is dedicated to it, and we will answer the questions, hoping really that we will have time for it, but I'm sure this will be the case. So to give you a short presentation of our speakers by order of appearance, we will start with Avi Singh, Professor Avi Singh. He's Deputy Director General at the UIA Institute for the Rule of Law. Specialized in litigation, he appeared in numerous court and tribunals, both nationally and internationally. He's an expert in international criminal law and also, among many other things, teaches international law at the University College in Turin, Italy. Our second speaker will be Clara Gerard Rodriguez. Clara is a member of the Paris Bar. She's an international criminal lawyer. She's currently based in Kiev. From 2013 to 2017, she worked as case manager and legal assistant at the ICC in different teams. She is, since November 2022, she's been based in Ukraine, working with the British firm Global Rights Compliance, which provides assistance to the Office of the Prosecutor General in Ukraine. Notably in the investigation and prosecution of international crimes, of course. Then we'll have the pleasure to hear from Caroline Bussmann. Caroline is a member of the Amsterdam and New York Bar Association. She's specialized also in international criminal law since 1999. She's also practiced at the academic level. She's now working with the UN. She joined the United Nations in 2019 and is leading an investigative team in Iraq. She is also the author of various books, chapters, and articles on international criminal procedural matters. Then we'll not end the panel, of course, but the last speaker will be Paweł Wilinski, chairman of the board of the project Sunflowers, professor of law, chief of the Department of Criminal Procedure at Adam Mickiewicz University in Poznań, Poland. He's judge of the Supreme Court of Poland. He's ad hoc judge of the European Court of Human Rights. He's also expert, of course, in criminal procedure, international criminal law, and teaching human rights law, constitutional aspects of criminal law, and authors of over 200 publications in criminal procedure, criminal law, and international criminal law. So we will now start with our first speaker, Avi Singh, who will give us a general overview of the rule of law and what it implies in situation of conflict, whether international or non-international conflict, and give us some notions of around the international crimes and the question also of complementarity in contexts such as conflicts. Avi, the floor is yours.
I hope I'm audible to everyone. Good morning, good afternoon, good evening, wherever in the world. I can't see who the attendees are, so I'm going to have to presume that they're in every time zone that there is. The first webinar that we did as we all moved online was the rule of law in the context of the pandemic. And here we are, some years later, dealing with another emergency or exigency. And it seems that the new normal, if there is to be a new normal, is the rule of law in an emergency situation. That is, of course, a very tricky thing because there is always a derogation of the rule of law in an emergency situation. Um, Romana, could I possibly have the presentation up? Thank you very much. I think we can skip through a few slides. Yeah, we can skip that, skip that. There you go. That's fine. So this is actually a chart by LexisNexis, which I'm sure you're all familiar with. The rule of law, of course, is a tricky thing. I mean, it doesn't just mean obviously following the normative law, because that can be draconian, as the rule of law, if you just think about following the law, would mean following even laws that are inherently unjust, inherently unequal, inherently not transparent, which doesn't have an independent judiciary, etc. So the rule of law must have basic features, and this is an issue which is really troubled. If you look at the World Bank Index for the rule of law, that's very different from what us legal practitioners would put together, and it deals more with the efficiency and the time taken and the costs of the legal system than anything else. But when we talk about this, the LexisNexis rule of law equation is as good as any. It deals with equality under the law, transparency of the law, an independent judiciary, and accessible legal remedy. The question, of course, is that this rule of law, which serves as a foundation for democratic governance, human rights, and peace, social stability, what happens to it in a time of conflict? If we can have the next slide, please. Conflict is, of course, by its very nature, a state of emergency. Whether we're dealing with additional protocols, which would, of course, be in the form of non-international armed conflicts, or the Geneva Conventions, which would be where there was an international armed conflict, like what we see between Ukraine and Russia, or Russia and Ukraine, regardless of what it is being called by Russia. Now, international humanitarian law, of course, regulates the conduct of armed conflicts. We have here a somewhat difference because, and these issues are very often conflated, the jus ad bellum, which is, of course, sometimes referred to as a crime of aggression, of whether it is legal to go to war, whether, and there comes in essentially the Westphalian system of dealing with the issues of sovereignty, and jus in bello, which is the conduct in war. And I'm sorry to going down to elementary, but we don't know where everybody's at. So international humanitarian law primarily deals, in theory, it also deals with the crime of aggression, but it deals with the conduct of individuals in armed conflicts, not necessarily that of states, though the conduct of states is a condition precedent. Of course, the respect for human rights, which is the common Article 3, that even in times of armed conflict, certain fundamental human rights is the right to life, prohibition of torture, prohibition against mass expulsion, etc., must be protected by all parties. The other fundamental principles, which I'm sure the other speakers will go through, are the proportionality and distinction principles. And of course, the fact that you must have a mechanism for holding people accountable within international humanitarian law if there is a breach thereof. And the failure to hold people accountable in itself is a breach of international humanitarian law. This is, in theory, though of course it is impossible to conduct this test, to facilitate peace building. If we can have the next slide, please. A part of the Geneva Conventions, as well as two of the additional protocols, which applies to non-international armed conflict, that is less talked about is the common Article 1. The definition, or part of the definition, is up on your screen. Undertake to respect and to ensure respect for the convention in all circumstances. So the states have not only an obligation to respect the Geneva Conventions, which of course goes without saying, as they are all signatories to it, as they are signatories to the Genocide Convention, but also, just as in the Genocide Convention, to ensure other states' compliance. So ensuring this, of course, involves creating necessary domestic legislations. But the question which has arisen recently is, are states also obligated to actually do something with regard to other states' conduct of armed conflict? Is there an obligation, both negatively and positively, to take steps in that regard? This, of course, what are those steps? Could be diplomatic action, which we see, domestic legislation, which includes having a legislation which allows for universal jurisdiction, a weapons review obligation, which looks at where weapons are going, a domestication of international criminal law, sanctions, and regulations of private armed actors. This is not, of course, a magic list of obligations. It differs from conflict to conflict, but this tells you that there is an obligation within the rules-based system, which all parties are signatories to, which puts on states, not on individuals, but on states, a positive obligation to ensure that states that are in a state of conflict, and we are of course not limited to Ukraine, unfortunately, conflict is rather more widespread than that. We have recently the case of Sudan, which of course is a non-international armed conflict, so the additional protocols apply, but there is enough foreign engagement and disruption to perhaps have elements of international armed conflicts, and hopefully doesn't spill into one, to ensure that all the parties therein are adhering to the laws and the rules, which includes non-targeting of civilians, which of course we've seen a great aberration of. Now, in this regard, there is also a requirement to ensure that the states that are, or parties that are engaged in armed conflict, are ensuring that detention, which happens invariably during a conflict, is done according to the Geneva Conventions or the additional protocols, as the case may be. This is something which in the last 20 years is a place where there has been great derogation of what happens in detention. We've seen extraordinary rendition. We've seen the issues of people being declared non-combatants, Guantanamo Bay, the detentions in Afghanistan, Abu Ghraib, Syria recently. And there has to be a corrective action, because it is not just the conduct of war, but what happens to combatants and civilians who are caught up in that. The second, of course, is the humanitarian aid to internally and externally displaced people. We've had a lot of issues in law with refugees, both internally and externally. And as refugees are invariably, not always, of course, a consequence of a humanitarian crisis, which is from a conflict, that is another positive obligation where a body of law can be built, which says that states have a positive obligation to ensure that civilians who are survivors or victims of a state of armed conflict are aided as such, rather than treated as undesirable in a particular territory. Now, of course, in this regard, we've had, just before Ukraine started, the rather terrible situation of Afghanistan, where the International Criminal Court has been acting, but rather more slowly and with much less international cooperation, and in one instance, at least, with the US, which will come across sanctioning the prosecutor, active obstruction of an investigation. So there have been serious jurisdictional and political constraints with regard to Afghanistan. In Syria, of course, Syria is not a member of the International Criminal Court, and Russia and China have so far blocked any reference to the International Criminal Court, If we can have the next slide, please. So the rule of law versus an international rules-based system based on sovereignty. This is a question which is actually somewhat tricky, because today we have a conflict in which the sovereignty of a country, particularly Ukraine, is and the violation of that, which is of course a violation of the international rules based on sovereignty, is something which is being held as equal to other violations of the rule of law. And this is something where the question, and it brings back into focus the question of sovereignty. We've had a derogation of the red line of sovereignty in the last decade, 2 decades, with the responsibility to protect. We saw that in and the humanitarian interventions. We saw that in Kosovo. We saw that in Libya. And the question then becomes is, what is the extent of a violation of the sovereignty of a country, a red line which leads to certain consequences? There is, of course, then the question of crime of aggression, which will get to humanitarian law, and then the complementarity jurisdiction of the ICC. Because the ICC, as many of you would already know, does not have original jurisdiction over crimes against humanity or war crimes. The ICC can only act where there is prerequisite, there is a serious crime, it rises to a threshold, that there is a crime of aggression, but also where the state, which is in itself where the jurisdiction lies, is either unwilling or incapable of acting. So in Ukraine, with regard to Ukraine, we've seen that the state of Ukraine, I know the other speakers are going to talk about, have had hundreds, if not thousands of prosecutions and investigations, and they certainly have a robust and a prosecutorial system which can bring these actions. So the question does arise whether this is a situation where the ICC needs to come in, or whether Ukraine can act on its own in a rule of law system. We saw that in Kenya, where the prosecution of the then president, which had started because it was thought that Kenya was unwilling to, in fact, act against political leaderships on crimes against humanity that have been conducted during an election campaign, was in fact stopped because it was decided by the prosecutor and the investigation that the ICC was in fact incapable of bringing a successful prosecution and investigation if the state was unwilling to cooperate with the ICC. So we come back to the same issue which we saw in Sudan till recently with al-Bashir's indictment, which we will of course see in Russia, which we are seeing today in Afghanistan, that if a state is unwilling to cooperate and unwilling to prosecute, then is the ICC possessing of the capacity, or is it also incapable, or in fact, of bringing a prosecution? Can we have the next slide, please? So the crime of aggression, for many reasons, is not based on the negotiations of the Rome Statute and the Kampala amendments, is not in fact one of the scheduled crimes in the Rome Statute, but an act of aggression is a prerequisite for individual acts. The other differentiation, of course, is that an act of aggression is the responsibility for states, and the international and the Rome Statute and the jurisdiction of the ICC is based on jurisdiction over individuals and not over states. Who does have jurisdiction over states is the International Court of Justice, where in fact just after the special military operation or the invasion by the Russian Federation of Ukraine, using the pretext used by the Russian Federation that this was a defense, that this was to prevent genocide in Luhansk and the Donetsk Oblast, the Ukrainian side took the Russians to the International Court of Justice, arguing that as the pretext for the invasion was in fact the prevention of genocide, the Jurisdiction conferred rather by Article 9 of the Genocide Convention was empowered the ICJ to resolve disputes over the interpretation, application, or fulfillment of the convention. VP Gevorgian and Judge Zhu disagreed that the ICJ had jurisdiction because it was in reality a question of legality of the Russian invasion, but nevertheless, the court ruled in an interim order that Russia must immediately suspend the military operation in Ukraine. Unfortunately, as is very often the case, this was not complied with, and currently Russia is not just theoretically, but in fact in violation of international law because it is not complying with a ruling of the International Court of Justice. But that's also more and more the norm rather than an exception. So the ICC, on the other hand, creates a dual obligation. There is an obligation on the state not to be an aggressor. There is an obligation on the state to comply with the Genocide Convention and the Geneva Conventions, as well as additional protocols, as is customary international law. But the second part of the dual obligation is the conduct of the individuals, which must carry out the obligations of the state, and falling short of this or failing to prevent or punish that, which is basically superior responsibility, they are then liable for crimes committed, usually on behalf of one side of an armed conflict, which is usually a state. Can we have the next slide, please? So one of the international law mechanisms that have been used, particularly recently and more, is sanctions. We've had, of course, the multilateral sanctions, which are becoming rarer because of the differences within the Security Council. So we've had targeted sanctions on the Taliban, we've had targeted sanctions on Al-Qaeda, we've had targeted sanctions on ISIS. There has been consensus in the Security Council on that. These are based on presentation by a state where the people who are targeted do not have locus or any hearings. And there is a sanctions committee established by the Security Council, which considers this presentation by a state of a sanction request. These are secret proceedings. And if there is, in fact, a finding that somebody goes on a sanction list, then sanctions can, of course, mean financial sanctions, an arms embargo, travel restrictions, and other forms of civil punishment. Now, this is something where under Security Council, chapters 6 and 7, there is an obligation on all states to, in fact, comply with the sanctions. We also have now increasingly, particularly in the Russian-Ukraine conflict, but in also in other conflicts, including civilian disputes such as Hong Kong, unilateral sanctions, wherein the United States in particular, but also the European Union, are imposing sanctions against individuals for their conduct. There are very serious concerns about transparency and due process, and of course, the extraterritorial application of unilateral law and what that does do to a rule of law or a rules-based multilateral system if unilateral sanctions replace multilateral sanctions, which in themselves had serious due process concerns. We can have the next slide, please. I won't go into this in much detail, except the arrest warrant for President Putin was issued under Articles 82A7 and 82B8 of the Rome Statute for unlawful transfer of population children from occupied areas of Ukraine to the Russian Federation. As I mentioned earlier, there are serious concerns still for the complementarity issue, because one question that does arise is why has not Ukraine targeted this? There have been other heads of state against which there have been arrest warrants issued. None of them so far have been arrested by the ICC. The warrants were also disclosed ostensibly to prevent further commission of the crimes. Now, in this the other person who was targeted was Maria Belova, who is the Commissioner for Children's Rights. The targeting of the Russian president by the ICC, of course, brings into question what is the jurisdiction of the ICC on non-signatories, because of course Russia is the non-signatory. Ukraine has made a specific referral to the ICC. It also brings in, and it is relevant, that the diplomatic immunity, which is of course not there for international criminal law, but there only if there is a domestic prosecution. But the US has enacted in 2002 an Armed Service Personnel Protection Act, which basically mandates that the US government protect US service personnel against any prosecution or investigation by the ICC. And this was the context in which the former prosecutor of the ICC was sanctioned or subject to sanction in the last US government for carrying on the investigation in Palestine, the situation in Palestine, as well as Afghanistan. And this, of course, raises the question that there are two very different yardsticks being used. The US, the ASPA, of course, doesn't come in the way of the US cooperation with the ICC because of the Dodd Amendment, which establishes a safe harbor that frees the government from the regulatory straitjacket of ASPA if they are rendering assistance to the ICC. The assistance must be provided only for international efforts. These international efforts must be aimed at bringing to justice certain individuals who must be foreign nationals and must be accused of genocide, war crimes, or crimes against humanity. There also is what is called a commander-in-chief waiver, which are presidential powers by which the US president can waive the requirements of ASPA for cooperation with the ICC. So in the context of the Ukraine situation, the US, like in Sudan, has been cooperating extensively and in fact supporting the ICC prosecution. If you can have the next slide there. I'll just briefly cover this, that of course, international criminal law or the rule of law in armed conflicts are having to deal with various other issues which have not been so common. One is cybersecurity. US and UK, of course, have a position that sovereignty doesn't apply in cyberspace. So it is in fact not a crime against the state if there is a cyber attack. But for example, France takes a position that this is a crime against the state if there is a cyber attack. And then, of course, what is the rule of law issues which have to be still worked out. For instance, God forbid, if there is a nuclear incident in Ukraine or there is a action by drones, as we saw above the Kremlin in the recent weeks. The other issue, of course, is private actors. If you can have the next slide, please. So just to sort of wrap it up, the long-term impact on the rule of law and democracy, every crisis like COVID leads to the derogation of the rule of law, and war is a particular crisis. Emergency measures are used as pretext, temporary measures become permanent, and democratic institutions are weakened. So the issue in tackling or bringing a rules-based system, which is in fact applies the same rule to everyone, victor or vanquished, irrespective of which side of the war they're on or which side of the conflict they're on, so that nobody can call the international criminal law victor's justice, calls for building a system which is truly rules-based and doesn't change the rules based on the situation. Unfortunately, there has been somewhat of a divergent in the way Afghanistan is treated or Sudan is treated vis-a-vis how Ukraine is treated. With that, I think I'll conclude and leave myself open for questions.
Thank you very much, Avi. Thank you. Maybe we will keep the questions for the end. Thank you very much for this general but still very detailed introduction to the different challenges that may rise in terms of rule of law in situation of conflict. you've addressed some of the interaction that might be difficult to understand in situation of conflicts, and for which I believe we will have very practical examples with the following speakers, which are notably the interaction between human rights law, and which part of human rights law remains applicable in situation of conflict in parallel with international humanitarian law. The whole issue also of the interaction between individual criminal responsibility and state responsibility, and the different courts and tribunals which might have jurisdiction. ICC is not competent for state responsibility. The interaction between domestic jurisdiction and, for example, the ICC jurisdiction, and the whole notion of complementarity, which of course quite often has a very political meaning before the ICC, and it's in fact very interesting to compare the different situations before the ICC to see how the very notion of complementarity may have very different meaning depending on the situation. And I think with the following speaker, we will have examples on Ukraine, and how Ukraine is a very good illustration of all the notions and topics that you just addressed. So I will give the floor to Clara Gerard Rodriguez, who will share her experience as a lawyer on the ground, working in gathering evidence in the different tasks that are the ones around the prosecution of the crimes which are being committed in Ukraine, and all the difficulties and the challenges that she may meet in her work notably with the local prosecutors. Clara, the floor is yours.
Thank you, Julie. Thank you so much, and good evening, everyone. So as Julie said, I have been present in Ukraine since November 2022, working with a British organization called Global Rights Compliance, which provides assistance to the Office of the Prosecutor General of Ukraine in the investigation and prosecution of international crimes. And I believe that the example of Ukraine and the examples of how the Ukrainian authorities uphold the rule of law on the ground during the conflict, as the conflict is ongoing, is a good illustration of the principles that Avi has presented in introduction. As you all know, since the beginning of the full-scale invasion of Ukraine on the 24th of February 2022, there have been numerous allegations of international crimes committed notably by Russian armed forces in Ukraine. There is, of course, the crime of aggression, which consisted in the invasion of Ukraine itself by the Federation of Russia and its civilian and military command, but also allegations of war crimes. Very early in the conflict, we've seen images of mass killings of civilians in Bucha, of the targeting of civilian infrastructures, notably in Mariupol. And since then, allegations have just been ongoing, and every single week bring new allegations of new crimes that may have been committed here in Ukraine. More recently, we've been starting to talk about allegations of crimes against humanity, notably in the context of mass detention of civilians in the occupied territories of Ukraine and in territories that have been recently liberated, for example, in Kherson, the targeting of energetical infrastructure in the country, more generally speaking, and even more recently have arisen allegations of genocide that may be committed by Russian forces in occupied territories of Ukraine. What does it mean in practice? It means that as of today, the prosecutors of Ukraine, either at the national, regional, or local level, have opened over 75,000 cases on war crimes allegedly committed in Ukraine. These 75,000 cases that are currently opened and that are being investigated. There have already been some trials conducted. In total, today, 75 Russian soldiers have been convicted of war crimes. Most of them have been tried in absentia, although about 10 have been tried in person and convicted, with sentences going from 12 years imprisonment to life imprisonment. Some of them are currently enforcing their sentences in Ukraine, but many, if not most, have been exchanged with Russia in the context of prisoners exchange. Those trials are being monitored, notably by the EU, since it also interplays with the new status of Ukraine as a candidate member of the, or candidate state to the EU, which means that the EU in particular is very attentive to the way those trials are conducted. And so I'm not aware of any broader report, global report as of now regarding those trials, the way they are being conducted, the way the principles and guarantees of fair trial rights are being implemented, but I am sure that such reports will be published anytime now, or that anyway, there are actors who are working on it, who are monitoring those trials, who will be reporting on how they are being conducted in practice. What I want to focus on now is mostly the investigation phase, since, well, that's the phase of the procedures I am most familiar with in Ukraine. I've been working on for about 6 months now, but also because it concerns the vast majority of cases that are currently opened. And I believe that the conduct of investigations and the challenges that are being faced by investigators, by prosecutors here on the ground are good examples as to how the rule of law may be upheld in times of armed conflict, but also of what are the obstacles and the challenges that are being met by actors in practice. As I said before, there are over 75,000 cases opened at the moment. It is obviously overwhelming for the Ukrainian judicial authorities, as it would be for any domestic and national judicial and law enforcement authorities all around the globe. There are, of course, challenges that arise from the conduct of hostilities itself. Part of the Ukrainian territory is still occupied. The rest of the territory is being shelled or targeted very frequently. Even here in Kyiv, last night we had repeated multiple explosions, about 12 missiles were sent on the capital of Ukraine. It of course creates a difficulty in terms of safety, in terms of security of the judicial actors who are trying to collect evidence, who are trying to just do their job in practice, right? Investigating, prosecuting international crimes. It also creates difficulty in terms of accessing the evidence. If we just think about the territories that are still being occupied. For example, the territory of Kherson region in the south of Ukraine, half of the region has been liberated, half of the region is still being occupied, which means that the prosecutors of Kherson prosecuting the crimes that have been allegedly committed during the Russian occupation of the right bank don't have access to evidence that may be now on the left bank, to the territories that are still being occupied, to the notably the detention centers that are still being run by the Russian forces on the territory, the part of the territories that is still being occupied. It also means that a lot of witnesses, a lot of victims have fled the country or are internally displaced and may not be easy to locate, to interview, to meet by the judicial actors. It also means, just very practically, that a lot of evidence will most likely be only accessible much later in time, because there will be maybe more insider witnesses coming from within the Russian armed forces. Maybe there will be some leaks of documents. With the liberation of the rest of the territories, there will also be more crime scenes, more evidence that will be accessible. Prisoners of war may be interviewed, and the interview may become relevant in proceedings that are currently opened. well, we'll see that we are in a situation that is constantly evolving, that is constantly moving, which means that the pool of evidence that is being accessible and that may be gathered by judicial actors is also constantly evolving and moving. And that creates challenges in the terms of just the flexibility it requires, but also in terms of just the need to preserve the evidence, to collect it in a way that ensures that cases are open and are conducted and are being preserved, to ensure that if new evidence arises in a few weeks, in a few months, or even in a few years, we don't restart from start, but they could be integrated in open cases. This massive caseload also shows the lack of resources of judicial actors, being either prosecutors or investigators, in terms of human resources, but also in terms of technical resources to effectively, efficiently investigate crimes. It means just very technically forensic analysis, in terms of or like technical new tools that could be used, for example, to analyze communication, satellite imageries, and all this that Ukraine doesn't necessarily have. Since the beginning of a conflict, there have been an effort from other states, including the US and EU member states, to provide such techniques, such tools to Ukrainian prosecutors, but they are still being implemented. It's not quite yet, we're not quite yet at the stage where all these kind of like more new, more modern, recent techniques of investigations may be fully used here on the ground. There are also challenges that just come from the difficulty that are being met when it comes to trying to translate or use the experience of prosecutors and investigators working on domestic crimes, on common crimes, and use this experience to investigate international crimes. We now have prosecutors, investigators who have spent their whole careers investigating common crimes and are being required to investigate international crimes without necessarily having the background, like the knowledge of what is international crimes, what is a war crime, what is the crimes against humanity, what are the elements that you need to prove to establish the criminal liability of perpetrators for those crimes, but also just in terms of specific tools and means of investigations and prosecutions are sometimes facing difficulties in how to translate the experience they have into what is required of them now. In some very practical example, it could be, for example, how do you build complex cases, joining several incidents and several cases into one, sort of, so to say, how to investigate situational cases within over one city or one region, instead of investigating separate incidents and conducting investigations separately. How do you build command chains or chains of responsibility to try to engage the responsibility of the higher command instead of limiting investigations to direct perpetrators? How to use linkage evidence to, again, engage the responsibility of indirect perpetrators? How do you use circumstantial evidence to prove all aspects of a crime when you may only have a few direct witnesses or a few direct testimonies? How do you use the overall pool of evidence that is being accessible to fully understand the context and the situation and all the crimes that have been committed, that may have been committed, and identify all the persons who may have contributed to these crimes? This requires techniques, but also just a mindset that is quite different from the investigation of domestic crimes, when you would most generally investigate one incident, one allegation of one crime against, you know, maybe a few victims by a few perpetrators, and that just requires, again, like different techniques of investigation, but also just to switch the mindset from like investigating one crime and one incident to investigating the overall criminal conduct that is being committed in Ukraine. There are also, on the side, difficulties that are created by the criminal law and the criminal procedure and the practices of criminal actors or criminal judicial actors in Ukraine. What is the most striking to us as international lawyers is the fact that Ukraine doesn't have crime against humanity in their criminal code. They do criminalize aggression, or like the conduct of an aggressive war, as it's called here. There are articles for war crimes, for genocide, for ecocide, but not for crimes against humanity. When we talk about modes of liability, again, the command responsibility, so the responsibility of a military commander who failed to prevent or repress the commission of crimes by his subordinates. This is not a mode of liability in Ukrainian law, which means that judicial actors need to be creative in the way they interpret their own laws, in the way they work around these obstacles or these limits which are created by the Criminal Code of Ukraine to try and investigate and prosecute criminal conduct in a way that is the most in touch with reality, in the way that is the most representative of the criminal conduct on the ground, but still being compliant, of course, and in conformity with criminal law and criminal procedure. When we talk about procedure, a difficulty may be the segmentation of cases and of work by offices of prosecutors in Ukraine. As I said before, there is the Office of the Prosecutor General, which has jurisdiction over the whole territory, but there are also regional offices and district offices of prosecutors with a geographical jurisdiction that is more limited. How do these actors work together? How do cases may be shared within those different offices? How do they share evidence? How do they share information? What happens when information that is being obtained by one regional prosecutor could be relevant to a case that is being conducted by another regional office? All of these are challenges that are just very in practice, needs to be faced, need to be addressed to conduct investigations efficiently and comprehensively. And again, I just want to say a word about the fact that this work that the Ukrainian judicial authorities, prosecutors, investigators, law enforcement agencies are conducted is on the side or on top of the investigation and prosecution of common crimes. There's still a common criminality in Ukraine. And for example, there is also another priority which has been very verbally addressed by the government of Ukraine, that is also a priority within the agenda or the calendar of Ukraine's potential accession to the EU, which is the fight against corruption. You may have seen that today the president of the Ukrainian Supreme Court has been arrested and placed in preliminary detention on charges of corruption. This is another fight that Ukraine is leading at the same time as the very practical hostilities, conflict that is ongoing on their territories, on the side of the tremendous work that is being done to investigate, to prosecute international crimes allegations. The fight against corruption is another priority, and it is met with other challenges, with other difficulties, but there are just so many prosecutors and investigators in Ukraine, and it creates just a massive workload, caseload on these actors. So all these difficulties will need to be addressed and create some obstacles in the determination that Ukrainian judicial authorities have to, in fact, uphold the rule of law and conduct investigation, prosecution, provide access to justice in times of armed conflict. I just want to say a quick word, I will be shorter, but on other challenges that arise from the multiplicity of actors present in Ukraine, the multiple judicial actors that have jurisdiction over the crimes committed in Ukraine or that are just simply present in the investigation of those crimes. Avi has mentioned it. Of course, the ICC has jurisdiction to investigate and prosecute war crimes, crimes against humanity, and genocide conducted or committed in Ukraine. 2 arrest warrants have been issued for the deportation of children against President Vladimir Putin and Maria Lvova-Belova. And other investigations are also ongoing at the ICC. There are notably investigations ongoing have been made public on the targeting of energetical facilities. Aside of the ICC, of Ukrainian authorities, there are also foreign courts, foreign judicial authorities that have jurisdictions over crime committed in Ukraine. Several European countries have opened cases either on the ground of universal jurisdiction or on passive jurisdiction because some of their citizens have been killed in Ukraine. This is notably the fact of France, which recently again announced that they opened a new investigation for the death of Armand Solin, who was a reporter, a French reporter in Ukraine who's been killed near Bakhmut. There are, I believe in France, 5 cases currently opened. In other countries, Germany, Spain, Switzerland, other cases are being opened, which means that those domestic judicial actors are also conducting investigations in cooperation or not with the Ukrainian judicial authorities. Again, aside from this judicial actor, Eurojust is present with a joint investigative team and recently announced the creation of the Center for the International Center for the Prosecution of the Crime of Aggression, which is supposed to be a preliminary mechanism to the creation of a possible international or hybrid tribunal to prosecute the crime of aggression, prosecute and try the crime of aggression. Again, those mechanisms, they collect evidence, they store evidence, they preserve evidence that may be useful for the investigation, prosecution of international crimes. Another wide range of actors are present and on the ground, conducting investigations themselves or assisting judicial actors in the conduct of investigations. That's the EU, that's the UN, there are many, many NGOs that are present in Ukraine, which of course creates quite a unique situation where we have a conflict and we have allegations of crimes that are very well documented, have a lot of information, a lot of evidence that arise, but at the end, very little coordination between all those actors, which create raise legal questions in terms of, Avi has mentioned it, complementarity between all those actors, complementarity between the ICC and domestic jurisdictions. It creates risk of non-bis in idem principle to make sure that the same persons are not tried twice for the same conduct. It also creates more practical risks in terms of replication of work, in terms of re-traumatization of victims or witnesses that are sometimes questioned by many different actors for many different purposes in many different investigations without necessarily any coordination between these actors and any caution being made for the well-being of the victim, of the person, the witness who is being interviewed, and to ensure that they are not placed in a situation of just recreating a trauma by asking again multiple questions about the crime that they have suffered. So what is crucial today, and I will finish by that, is better coordination between all these actors, better coordination in the way resources are spent and in the efforts that are being made to ensure that the rule of law is upheld, to ensure that victims have access to justice, to ensure that investigations are being conducted in an efficient manner, in an effective manner, in a comprehensive manner, but also in a way that preserves the well-being of all the parties involved, on the way that preserves fair trial rights, and on the way that preserves the evidence to make sure that it could still be used and admissible in the long game, because there is no doubt that the prosecution of crimes committed in Ukraine will take years and years in the coming years. Thank you so much.
Thank you very much, Clara. Thank you for this overview of the so many difficulties and challenges that that you and the justice is facing in Ukraine. You addressed so many very interesting things, but time is flying, so I won't be too long. Just noticing that just the number of cases which are open is by itself just such a challenge. apart from the fact that in principle, we can question, of course, the independence and impartiality of trials being held before tribunals in a country at war. It is, in fact, as such, something which is very questionable. And being also reinforced by the fact that, I don't know, I had a number of discussions with lawyers from Ukraine, being extremely critical to the judicial systems, the judicial system as it exists in Ukraine in terms of independence and impartiality. And you said also this thing that apart from what is going on in terms of international crime, there's a number of proceedings on corruption, and those questions are, of course, a part of the debate on how those trials are being held in Ukraine. So many difficulties, practical on a practical point of view, but also very interesting on a legal point of view, how there's a specific definition or conception of a number of notions which imply understanding them in order to find the good evidence. For example, depending on the modes of liability and a number of things you said were important to know what you're looking for, actually. So I guess it must be very interesting too. Just you also mentioned briefly the question of the trial in absentia. We know at the ICC, trial in absentia are not in principle allowed, but as you may know, the prosecution is considering having a decision on the confirmation of charges in the Kony case, one of the Ugandan case, in absentia, because there's this idea that it's still something, it might still be something, even if in absentia, for the victims, but there's a very large debate starting on should the ICC go into that direction, having trials in absentia. So this is one of the very many very interesting points you addressed. Without further delay, I will give the floor to Caroline, who will probably address some of the same issues and questions that Clara addressed, but in a completely different context, which is the context of Iraq. So please, Caroline, the floor is yours.
All right, thank you, Julie, and thank you for all the speakers, and good evening, morning, and afternoon to everyone. Yes, I will be touching on very similar subject area, and that is the investigations in a conflict situation, looking for evidence to prove crimes against humanity, war crimes, or genocide. This is what I'm currently doing in Iraq in the context of the ISIL crimes committed by ISIL against all ethnicities in Iraq. And all ethnicities also include their own tribes. Some of them were also targeted. So I've been doing that for the last 4 years. I was mainly focused on the Yazidi cases, but now I've moved to other minorities as well. So let me first properly address the mandate, how we're going to go about it, how to conduct proper investigations, and the challenges, and probably the way forward. Our mandate is to investigate those crimes, but not only for the collection and documentation of the evidence of ISIL crimes, but also to bring those accountable, those most responsible to account. And that is probably the main challenge. We are dealing with the Iraqi authorities, but also many other groups or entities that are also investigating, and also other states, because a lot of the ISIL members were either from different countries, a lot of foreign fighters joined, and also many Iraqi or Syrian foreign fighters have fled to Europe or other countries. So there's a lot of investigations going on, a little bit like what we heard about Ukraine. We have a bit of a similar situation in Iraq. What we do, we are in our collection of evidence and conducting the investigations, we apply what we call best international standards. But it's very hard to define what those best international standards are. And again, some of this has already been touched upon. We have very different countries with very different ideas on what is, what is the right approach to evidence? How do you collect it? How do you record it? And also what standard of proof is to be applied. Now, it's not controversial to say that when we want to prove a case and we want to actually find someone guilty for such international crimes, that the standard of proof should be beyond reasonable doubt. But that doesn't necessarily mean the same for all. And just to give an example, in my own country, the Netherlands, you cannot rely on one witness only. You have to have at least corroboration of a witness statement. You can also not rely on a confession only. That also needs to be corroborated. But that is not true everywhere else. All the countries have their own rules of evidence. In Iraq, for instance, they heavily rely on confessions, and it's something that they also strongly believe is credible and important evidence to have. But at least we try as a minimum to build strong cases on credible evidence, and that credible evidence has to be of such nature that it stands the test of time. And I think Avi already mentioned that if the investigations are not credible, then they can be challenged in the future. And we're dealing with very politically sensitive environments, like in Ukraine, the same in Iraq. There is our mandate is limited to ISIL crimes, so we will not investigate any of the crimes potentially committed by other parties, those fighting ISIL. But even within that, it is important that we get it right, and that the community, the Sunni community in this regard, is not marginalized, but that actually the cases are built on real and concrete evidence. So for that, investigations must be ethical, independent, transparent, but also confidential. When I say independent, I mean independent of national authorities and other NGOs, but also the communities and also the victim communities. It is easy to be carried away by the stories that are really, really heartbreaking. And when I think of the Yazidi community, they have suffered a lot. Not only a lot of killings, there's been not a lot of sexual violence that was committed at very large scale. And that meant that pretty much all women who were taken in captivity were taken in as sexual slaves. So it's something that has deeply affected the community. Many of them are still, they haven't returned. So we don't know if they're dead or alive, or if they're still held in captivity. And from time to time, even nowadays, women return from captivity. Boys were taken in and were trained to be child soldiers. And a lot of them were indoctrinated and have been transformed forever, if they are still alive. So it's huge. And yet again, in these sort of situations where the atrocities are so heartbreaking, so affecting mankind of whole, it's even more important that we apply the rule of law. And what do I mean by that? Even when we're looking at the evidence that is provided by survivors of such crimes, we tend to take it for granted that whatever we hear is true. And that is not necessarily the case. Also, victims They might lie. And it might be that their perpetrator is no longer alive and they want to blame it on someone else. Or they're traumatized heavily, and so that affects their memory. It can also be, which is true in many situations, and particularly again in the Yazidi community, where they live all together in camps because they cannot go back to their homeland. And what sometimes happens is that someone in the community knows of someone and believes that that person was responsible for the crimes. And then many others in the camp take over that evidence and make it part, they transform it into their own memory and make it part of their story. It's something that we have to be mindful of when we do these investigations. And that these are just a few examples. But as I said, second point is that these investigations must be transparent. And if I say transparent, that's of course with full respect for confidentiality and security of the witnesses you might interview, and also the security of those involved in the investigations. We also heard from Clara how volatile the situation is in Ukraine. It's the same in Iraq. There's many different interest groups from different countries trying to run different areas in Iraq, and they all have different interests at heart. Yet, when I refer to transparency, I do mean that every step that you take in conducting your investigations must be properly recorded, so that later on you can show how you came to find a certain piece of evidence. And this is particularly important when we are conducting online investigations. It's really important that the whole, all your steps from A to Z can be traced. I already touched on the confidentiality. It's important to be mindful of the security and safety in a particular area. And there is a balance to be struck between protection of the people you're interviewing and the protection of your investigations. And also then that has to be balanced to the fairness to those that will ultimately stand trial. A lot of this is a determination for later. A court can impose protective measures, but already at the level of investigations, there's always this balance that you have to be aware of. We, for instance, we are guided by the principle that our interviews are victim-centered. It means that the interviews can only be conducted on the principle of voluntariness. Nobody can be forced to cooperate with us. We try to make it as comfortable as possible for those that we interview, and we cannot force them to give us any answers. We give them breaks when they need, etc. At the same time, for the evidence to be credible and to be relied on in a proper court that respects the rule of law, the evidence must be tested. And that can be done in multiple ways. You can try to find corroborative evidence, but also I think it's important, it's your ethical duty to test your own evidence. And that might mean asking some uncomfortable questions to the witnesses. So that's also part of the ethics of the investigations. And of course, ethics is very wide, and it's maybe something very easy not to pay for information because that might actually have an impact on the credibility of that information. Of course, not planting evidence or exaggerate the findings of your investigative steps. But also very important is, as I said, the scrutiny of your own evidence, and to be aware that your evidence might actually not be as reliable and as credible as you would like it to be. And in that regard, I think we have to be mindful of what I would call confirmation bias. That means that we already have the conclusion in mind and we color all the evidence that we find in that light. And we've seen this over and over again, how different a look we can have at the evidence, whether, you know, depending on what side you are. So I think this is something to be really, really mindful of, and to be careful not to investigate with a so-called tunnel vision. A full and thorough investigation includes looking at both incriminating and exonerating evidence, equally ideally. So that means you cannot ignore when there is an alternative interpretation of the evidence. You have to be mindful of that. And for instance, in the context of a war, Avi already touched on some of the principles, but then we look at it, it might look like someone is attacking a civilian hospital or attacking a civilian. But when we look deeper at the context, it might well be that the civilian hospital was used by the army, or even that the suspect was in a reasonable belief that this was the case. And the same with civilians. Some civilians are armed and then they lose their civilian status. There's also, if I come back to Iraq, then we look at other people who were involved in the conflict against ISIL. There's been many people who were killed through bombing of what we call the coalition forces. Now, that could be collateral damage, but that is something to be determined in the circumstances. And we need to be open-minded to all those circumstances. Again, as I said in the beginning, for a credible investigation to stand the test of time, it's important not only to listen to a one-sided story, but to listen to all sides, and to also investigate widely into the crimes against all ethnic communities. Specifically in Iraq, one of our main challenges is that in Iraq itself, there is the death penalty. And we as a UN agency, we cannot share information that may be used in a case that involves the death penalty. This has made it very difficult to really work together with the Iraqis. But the Iraqis themselves are trying ISIL members on a daily basis. They're not doing this under international criminal laws because they don't have in their law that there's no law on war crimes, crimes against humanity, or genocides. So they prosecute, investigate, and prosecute under terrorism law. That was true for many cases, for many countries outside of Iraq as well. But recently there is a new approach, and many of the states that are dealing with these cases are looking at those crimes not only as a crime of terrorism, but also as a crime of genocide, war crime, or crimes against humanity. Iraq has not, as I said, incorporated this law. They have obligations under the Genocide and the Geneva Conventions, which they have at some point signed and ratified. And under these conventions, they actually have an obligation to prosecute and investigate such crimes. But for now, this is a gap that we are faced with. So we are looking also very much at other countries and where it's easier to collaborate. And this is something that is more and more developing. But of course, you always have to be mindful as an investigative body. We're not a court, and we don't know which court will ultimately assess our investigations, our evidence. And the rules of evidence are different in different countries. And there are many questions that you have to consider. For instance, if you have an opportunity to interview a detainee, but you can only do it without video and audio, you have to be mindful, if you do that, it might be inadmissible in some countries, and maybe everything that comes out of it, if there's leads that you get out of that interview, that might also be inadmissible in certain countries. While in other countries, it might be completely acceptable. So this is a challenge. There's other examples. Can you use, for instance, campaigns online where you, like maybe not you, but you're working with an NGO that publish a picture of a suspect. That is something that might be acceptable in certain jurisdictions and not in others. So in any event, we are like reaching now more and more a sort of uniform way of investigating these kind of crimes. There is like the minimum requirements in conducting interviews, particularly with vulnerable witnesses, we need to all respect. But another example, can you search on the web and not disclose who you are? Again, these are questions that involve not just ethics, but also potentially admissibility. I would also like to point out, just like Clara, and that might also be my last point, that the main challenge is indeed that so many different entities are involved in the same investigations of the same perpetrators of the same crimes. When we're dealing with foreign intelligence, forget about getting the evidence ever. There is not a good sharing of information system. We are much further advanced from where we started, especially in collaborating with NGOs. And there's now, with many of them, we have set up some sort of sharing mechanism. But the sharing is one-sided because we can only share with states and not with NGOs. And of course, NGOs often have different objectives. They haven't necessarily interviewed them with the same perspective, and they also apply different standards. Sometimes you have vulnerable witnesses who've been interviewed multiple times, and not only is this a problem of re-traumatization that was not necessary, but also you create a lot of inconsistencies because different questions were asked. And we have to be mindful that in our maybe enthusiasm to find a certain answer, you have to be very careful not to lead the witness into what you want to hear. Like Clara said, we also have a huge security challenge, and the stability is constantly is changing all the time. Also, once we have identified the perpetrators that we really want to focus on, then some of the witnesses might or might not be alive, or they can be living all over the world because a lot of them have left Iraq. Some are unfortunately have deceased or are still in captivity or so traumatized that they can either not cooperate or not really. So my recommendation would be really a little bit like Clara's. I think the only way we can do this properly is to have very proper collaboration among NGOs, states, and everyone else involved in collecting the evidence. It's the only way forward. And in a way, we have one good example in the case of the Yazidi, where many states now are working together in collecting the evidence and interviewing the evidence, which means they do not need to be interviewed multiple times. And also in building these cases together. And I think that is what I would recommend is the best way for the future. Thank you so much for listening.
Thank you so much, Caroline. Again, so many interesting things from this practice on the ground. I just to that in the collection of evidence, you need to have both a long-term vision and a multiple vision. For example, when you said the question of the standard of proof, which might be different from one system to the other. We both have been confronted to that with our domestic practice and practice before the ICC. This is extremely interesting because, of course, all this work that you're doing, both you and Clara, needs to get out of our education in terms of law and practice and get a bit out of the box to try to understand that we may have to function according to different standards, the standards of the country, the standard of the mechanism or the jurisdiction we're collecting the evidence for. The question of admissibility also very interesting. The importance of the confession, you said, in the domestic system, which is not necessarily so important in different systems, might not be so important. Also, I liked what you said about not having a tunnel vision on the evidence and try to be receptive to different points of view, the different parties in the situation for which you're trying to collect evidence. And being a representative of victims in several cases before the ICC, I can see how important it is how important the work on the credibility and reliability of the evidence provided by victims, by survivors, by persons who have been traumatized. It's very difficult. It's very difficult. You can have a narrative which was built because of the circumstances, and it's an evidence which is with which you have to be very careful. So yeah, it is very important to have the good tools to assess this, specifically in situation of atrocity crimes and mass crimes with community involved in those kind of crimes, and not, like you said, having this tunnel vision either on the side of the defense or on the side of the victims. So it's extremely important. Just to finish also, yeah, the collaboration, as you said, it seems to us from the external point of view that probably one of the biggest challenge and probably one of the first one, if we have the whole different systems that are being put in place in terms of collecting and treating evidence and then the trials and so on. Because, as you said, there's so many different actors on the ground, is of course the collaboration. Thank you again. So from there, we will have our last panelist, Professor Paweł Wilinski. I'm thinking maybe from what we've heard in terms of acting in the present, what can we do for preparing the future in terms of a future would be respectful of the rule of law and of fair trial. So, Paweł, thank you. The floor is yours. Thank you.
Oh, thank you, Julie, and hello, everyone. I represent here this webinar Sunflower Foundation, which is an organization established shortly after the beginning of current period of war, so from February 2022 in Ukraine, to collect information of evidence of crimes committed during this conflict. So what we do is we do not collect evidence, but we do collect information about evidence. Among, of course, Ukrainians in the territory of Ukraine, but also among refugees all around Europe and far away outside Europe. So in Poland, Slovakia, Czech Republic, in Germany, also France and Spain, Lithuania, and many other countries. We do that because we believe that collection of information of crime is crucial for the future delivery of justice. And this is what I will have some comments on. The topic of my speech is fair trial in the country of war. But being last speaker, I have a privilege to refer to previous presentations to make my speech shorter. Let's hope that I succeed in doing so, because there's so many interesting points that we should be raised. What I would like to attach your attention would be 5 issues. First would be subject of prosecution. Second would be some additional issues of admissibility. Third one, trial in absentia, and then question of fair defense for accused, and then some comments on national versus international prosecution and possibility of creating a coherent system. When we are looking at Ukrainian efforts, we see that they are doing a great job trying to start the justice procedure. We all want the justice should be done, and we all hope that it will be delivered in Ukraine. But of course, this is not very easy, and the country facing war is in a very difficult situation, because face external and internal problems. And in their perspective, effective prosecution is one problem. Effective trials and delivering justice is probably completely different problem, or the further perspective. Problem that face Ukrainian system and the prosecution and judicial system to prosecute and to trial perpetrators is connected, of course, with the moment of evolution of criminal law in Ukraine. This is connected much with the standards of international criminal law introduced to national system. So the first comment will be connected with the problem of subjects of prosecution, and it's in some way supplement to the comments given before by Clara. Of course, we have a basic problem for what Ukrainians can and shall and want to prosecute. We hear that, and we know that Ukrainians don't have a definition of war crime in their code of criminal law. They didn't implement it that. They didn't implement it that standard, which doesn't mean that they do not recognize all those forms of crimes that are committed now. All those forms are, of course, defined, so they have murder, rape, sexual abuse, but they don't have them in this special context of war crimes. And then when we speak about cases open about the war crimes, we have to understand that this is not exactly the meaning what we should think of when we think about opening a case on war crime from international law perspective. And obviously, at the same time, we have to answer which is the law that they refer to when they present charges to a person, to the suspect person, trying to bring this prosecution before the court. Ukrainians face this problem discussing and asking themselves what should they do. They, of course, have in mind what is stated in Article 8 of the Statute of International Criminal Court. And probably even more how much detailed it is defined in the special document called Element of Crimes. But this is not only the definition from the Rome Statute. This is also the jurisprudence of the ICTY or ICTR that put these war crimes in a specific context. So we try to put their attention to some basic definitions coming from those 4 Geneva Conventions from 1949, and trying to convince to introduce a basic legislation and at least basic principles, which will give them a chance to refer to jurisprudence of international courts. This have some importance now, but probably will have some much broader importance in the future, when the conflict hopefully will be closed and there will be more and more trials. Some will have to be repeated anyway, those in absentia, for example. But when we speak about definition of war crime and implementation to Ukrainian system, we have to understand also very specific perspective. It is very risky, or I would say it is not easy and difficult to convince state of war to implement new crime as war crimes, because on the field of war, crimes are not only committed by one side. And this is, of course, something that will not be spoken openly. But if you have both sides fighting, and even if you have evidence of obvious and horrible crimes committed by one side, you can expect that someday, some way, somehow, you may have some totally different evidence. We don't have to refer very far to see that this is true. If we remember the Afghanistan case and the history of prosecuting of Afghanistan case before the ICC and the decision of pretrial chamber of the ICC, seeing no interest of justice in opening case of Afghanistan, and the real reasons for this decision in the context of future possible responsibility of the members of, for example, some big players, soldiers, stating in Afghanistan, we can understand that this is not very easy answer if this is obviously time for implementing. But without implementing, from another side, this definition, it is very hard to say that they really prosecute for war crimes from international criminal law perspective. So this is one, I would say, huge problem to be discussed. The second is raised already question about the admissibility of evidence. So I will not refer to collection of evidence, as it was so great presented by Clara and was mentioned before. I strongly believe that admissibility of evidence is a core problem of the future delivery of justice, and will and shall be the core problem of the fair trial standard and effectiveness of international system. If this is a problem for a country system, country legal system, my system, Polish, French, or any other, always admissibility of evidence is an issue. So if you can imagine that you can have these 10 times bigger if you speak about international community, then you can realize how big problem it may and it will be. This is what we have to realize, the question of admissibility of evidence in the international field, international criminal law perspective. It's a specific mixture of common law standards and civil law standards. So the answer, if the evidence is admissible, can be different before different courts. This is obviously something that Ukrainians have to understood, and they do understood, working with them for more than a year. We realized that they adjust very fast. They train, they learn, and they try to understand these basic rules of admissibility. But those basic rules are not very easy, even for those that that deal with this for a long time. This is a question of contamination of evidence. This is a question of access to objective evidence. in the field of war. If we speak about Bucha and the place when we can get the evidence and the international communities and their representatives to take part in collecting evidence, it is something completely different that we speak about what happens now in Crimea, or it's happening in Bucha, where crimes are also committed and some evidence shall or can be collected. This is a question of testimony of victims, of captured soldiers, or of war prisoners, of questioning of those people, and the reliability of the evidence. That was just shortly before mentioned by Caroline. She's completely right, saying that this is not a problem of having a video recording of the testimony, but admissibility of the evidence depends on so many external elements, like the aim of collection, the moment of collection, the position of the person witnessed, circumstances that the evidence is then kept and presented to the court as of a great importance. That means that for sure these issues will be raised by lawyers before any court. Doesn't matter in which jurisdiction and which system they will be presented. We know this lesson from what happened before the ICTY Tribunal for former Yugoslavia. We know that from Rwanda. This is a great lecture that we had from special panels in Cambodia, what we saw in Kosovo and in many, many countries. Number of evidence is huge this time, and for now is still huge, but the number of evidence is not the same as the value of evidence. So from my perspective and the perspective of the Sunflower Foundation, the most important problem now is not collecting evidence, but collecting information about evidence. In the meaning collecting sources of information about sources of evidence, to be able to deliver this information where you can collect evidence by yourself to any tribunal, any court that will handle these cases in the future. This is what we do because we believe that admissibility of evidence is based mostly on circumstances of collection of evidence. And this is very visible from international criminal law perspective. Which is what is the importance of evidence itself is a huge lecture from the history. Historical perspective is a great teacher. Even if we stay in this circle of Russian influences and we go back to the history, we can raise questions and situations that have been forgotten. Probably no one, or very few people still remember the crying step, which is the famine crime in Kazakhstan in the 30s. It is estimated that 5 to 7 million people have been killed, and it is called also the Stalin's genocide and the crying step situation. We know very little about this crime because we don't have evidence. This is the same story and the crime against Jadids. Jadids, this is not Yazid, what we speak today, but Jadids, this is the story of the Uzbek nation and the crimes committed in 1936 and 37. The crime on the huge scale that the history of the Western world do not remember. What we do remember, but very little, is Holodomor, Ukrainian genocide, the genocide committed by Soviets on Ukrainians. But we know so little about this, and we have no chance to raise a question about justice because of the evidence. There is no evidence that we can present. I always ask Ukrainians, I always ask Kazakhs and Uzbeks, can you give me an information understood as evidence of those crimes? I can share with you a very strong impression, that one of the last impressions. I heard a song, Uzbek song, traditional song, which is an evidence of the crime committed in 1936. This is a song of people watching the tree with hanged people, knowing that only birds will feed with these bodies, but they will not be able to bury them. This is the song that is a traditional song sung by Uzbeks every generation after generation. So we don't have evidence that this crime have been committed. We just have some information, but we have this song, which is an evidence, the strongest evidence ever can be fought, because kept in tradition and the memory of the nation. But we have no chance to deliver justice. I will skip the comments on trial in absentia because it was already mentioned. I will only can say that from Ukrainian perspective, we have to understand that it is not always the trial that must be the aim. Sometimes when we see those trials in absentia, we really see pre-trials in absentia. And we have to understood that sometimes it will be only these. There will be no trial, but this is only pre-trial in absentia. And sometimes because of transfer of people and no chance to transfer subjects to under Ukrainian jurisdiction, we will have cases that will be opened. We will have charges that will be presented and openly presented against people that will never be brought before Ukrainian or international legal system. So we will call that a pre-trial in absentia. And sometimes it is okay because its aims will be different. But when we speak about trial in absentia, we have to understand that this cannot be really understood as meeting international criminal law standards. But this is not a problem because they can be done again if the person will be surrendered to the Ukrainian legal system or to international legal system. We can have a trial again if we will transfer the person and if we will have evidence, and if this evidence will be admissible. Then the fourth perspective, the fourth issue is the fair defense. When we speak about fair trial, we see many issues, but one of them, even if we speak about crimes committed against Geneva Conventions, war crimes, there is always also an element of this. This is a right to defense. This is different standard that we saw in Nuremberg, that there was no appeal, but there was said that, of course, they had a right to defense. The standard of right to defense delivered and from international law standards and stated in international law, like European Convention of Human Rights, the different conventions of human rights, Chapter of Fundamental Rights of European Union, and other international agreements, gave us lectures that right to defense have to be delivered to any accused, to any suspect and any accused. It means the possibility to call evidence, free access to evidence, the questioning of witness, the right to questioning of witness on the standard established in Article, for example, in Article 6.1 of the Strasbourg Convention, right to appeal against the verdict. But something that is really the core issue, which is right to defense lawyer. So then we ask the question, what defense lawyer should have the suspect? Ukrainian defense lawyer, Russian defense lawyer, French, Polish defense lawyer? We have this lesson from cases before Yugoslavian tribunal. Remind you the Milosevic case and his problem to cooperate with people forced to be his defense lawyer, but saying that the suspect need to have a defense lawyer of his choice. is, for example, a question whether there will be any Russian defense lawyer able to come to Ukraine or any other place and get back to his own country secure way. If he will be able to deliver the defense, if those other lawyers experience from international criminal law perspective will understand the perspective of the trial pending before national system. And lots of questions of this kind within the admissibility, because what the council will do will question admissibility of any evidence collected now and preserved for the future. So this is an issue that should be, of course, detailedly discussed. And then national versus international prosecution will be my last topic of comment. Is the question which system serves best interest of justice when we speak about the fair trial, or when we address this as a rule of law concept. Both are very similar, as you probably know that. And then when we ask this question, we have to understand that it depends on definition, because justice for society, for the country, is very often synonym of revenge. It is quite different than justice understood by international community, because from international community perspective, as from my knowledge, it is very often only a symbol, very often have a symbolic meaning, and it's fulfilled on this symbolic scale. When, for example, we speak about the Rwandan conflict and the activity of ICTR. So if we count only trials before the International Tribunal, this is not even 1%. If we include JECACA courts, then we can have very few percent. And then we have cases like the last one that I have been discussing with my students, a case of a man that that was sentenced for killing of 9 Tutsi. And he was sentenced for these 9 lives to 7 years of imprisonment by JECACA. So we've been discussing what kind of justice is this. From any national perspective, justice means something totally different than from international law perspective. So when we speak about fair trial, we have to understand that the answer, what this means, is different when we speak about special panels in Cambodia, and including international criminal law somehow in some way to the traditional way of justice understanding in Cambodia. But this is totally different when we speak about Colombia, for example, the restoration and peace agreements. And this, in this perspective, of course, transitional justice, what we saw in Kosovo, Lebanon. But if we speak, we have a very different answer when we speak about the Sierra Leone and intervention of UN, which resulted in this hybrid court. And then we have a special courts, we call them ad hoc courts, like the Rwandan and Yugoslavian court. And we, of course, have International Criminal Court with this or that way limited jurisdiction, supplementary jurisdiction. We have universal jurisdiction that was mentioned today, which opened these issues and gives us a hope that this system will be supplementary. And this is my last comment, that if we speak about fair trial from the broad perspective, we have to understand that we need to include all these elements: national legal system, cooperation with international law, universal jurisdiction, and national jurisdiction of countries like Poland, Netherlands, Canada, France, Germany, Spain, and other countries. And probably thinking that after, when the war will be over, there will be possibility of maybe creation something that we miss, which is connected with lack of possibility of prosecuting for crime of aggression. But all this is subsidiary to the national legal system, Ukrainian legal system. So what we should do is to sustain Ukrainian legal system, to support them in understanding that if they want to deliver justice in the way that we will be able to recognize this as meeting international law standards, it have to be done sometimes a bit differently that they have been used to do it before. And of course, for all of this, we need universal system of collection of information, of evidence of crimes committed in Ukraine. Thank you very much.
Thank you very much. Thank you very much. Very interesting. Thank you for giving us this idea that at one point we should make this distinction between collection of evidence and the whole very important issue of the information on evidence, the quality of evidence, and the whole questions which is linked to the first one on admissibility. So it is important, as we lawyers may have, as we say in French, le nez dans le guidon. So we need to take a bit of distance to be able to think over what information we do have on the evidence and what the quality of the evidence is. So extremely interesting for all those questions and the different other questions that you've addressed. Unfortunately, we're running out of time. We have a question that I would like to ask maybe Clara, because she seems to be the one who may respond this maybe very quickly. The question is ethnic cleansing being taken into consideration among the patterns involving crimes against humanity in Ukraine?
So at the moment, Ukrainian prosecutors are focusing on allegations of genocide in occupied territories and are, more importantly, trying to assess how the intent to destroy requirement of the crime of genocide could be met in Ukraine when the facts at hand, investigations are still ongoing, there are still a lot of gaps in the knowledge that we have of the criminal conduct of the Russian Federation in the occupied territory. But the biggest question at hand is whether the politics that have been put in place by the Russian occupiers that tend to filtrate between good Ukrainians that can be subjugated to Russian rule and that would adhere to the idea of a one nation people between Ukraine and Russia, and the idea that Ukraine has actually always been part of Russia as it is being claimed by the Kremlin, whether the intent to not physically destroy the Ukrainian people as in like individuals, but destroy the sense of belonging as a nation, as an identity, common identity, this could qualify as genocide. So this is really what the authorities are now focusing on. So it's not so much like ethnic cleansing in the sense of like trying to repress, suppress one ethnicity from an area, but more the claims that are trying to eradicate the sense of belonging, the sense of national identity from a people. Would that be constitutive of a crime, and notably the crime of genocide?
Okay, thank you. Thank you very much for this very clear answer. I think I have now to pass the floor to Jackie for the announcement for the next seminar, the next session of the Webathon. But first of all, I want to thank all of you. It was really extremely interesting. I learned a lot from the different interventions today and many things. It's like just a debate starting. There's so many things to to be discussed from what you've said today, and we'll see, of course, what the future tells us from what you've told us today in your different speeches. So thank you very much to the both of you. Jackie, it's up to you now, I think.
Thank you, Julie. Thank you for leading this intrepid panel. It was fascinating, and I learned a whole lot too. I want to thank all of our participants for joining us, and just tell you that our Webathon does not end here. Please continue to join us tomorrow at 1500 GMT, 1700 CEST, and 11 a.m. Eastern Standard Time for another fascinating panel entitled Combating Human Trafficking and Modern-Day Slavery Through the Rule of Law. To register for that program, you can click on the link that has been posted in the chat. And we look forward to seeing you tomorrow, and thank you very much for joining us.